Hello everyone, and thank you for tuning in to today's webinar. We have a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please let us know in that same questions tool, and a member of our admin team will be on hand to support you. And finally, just to note, today's session is being recorded and we'll be sharing a copy with you all via email in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Hello, everyone. My name is Stanislav Rumyancev. I'm a senior lawyer with Gorodisky & Partners, Moscow. And I'm here with my colleague, Sergey Medvedev. We will be happy to, hello, Sergey. We will be happy to deliver this presentation about the new internet law concerning foreign companies. So, as you may see from the title, Russia makes internet companies go local. It means that some companies doing online business will be required to comply with the provisions of Russian law, and among other things, it will be necessary to open physical offices in Russia. This law was adopted this summer, not long ago, and the main idea here is that Russia wants to establish some good communication with the IT companies, because for now it's very difficult for the Russian authorities to contact global IT companies and, for example, request them for deleting information or request them for doing something. So the Russian authorities believe that this law will help them to communicate and will help them to enforce the Russian legislation. Now we will see what it is all about. Let's begin with the scope of application of this law. Then I will explain you the main requirements prescribed by this law and some other laws. Then we will talk about coercive measures. And finally, we will try to understand what should we do in this situation. After that, I will give the word to Sergey Medvedev, and he will explain you in more detail what does it mean to open an office in Russia, how to comply with this requirement, and what is it all about. Scope of application. As you may see on the screen, the new law entered into force on 1st of July 2021. There are two exceptions, and one of these exceptions is the requirement to open office in Russia. This requirement will enter into force beginning 1st January 2022. But the main part of the law is already in legal effect. Here on the screen, you can see the official name of this law. It's very complicated, so it's the Federal Law on Activities of Foreign Persons in the Information and Telecommunication Network Internet. So to make it simple, I will call it just the law. The new law applies in several cases. First of all, the new law established several criteria, some applicability tests that will help us to understand whether this law applies to your company or not. However, in addition to the applicability test, there are several specific cases when the new law will apply for sure. So let's begin with the applicability test. The law says that this law should apply to foreign natural persons and legal entities. But of course, we will focus on foreign companies doing online business. The law will apply if a foreign company is the owner of a website. The second option is that this company may own just a page on a third-party website. I believe that this may apply to marketplaces or to some global platforms. The third option is that this foreign company may own some software available online, like mobile apps for Android or iOS. And the fourth option is that the foreign company may own some IT system, for example, cloud-based solutions like software as a service or platform as a service, anything like that. So if a company owns any of that, then this law may apply under some additional conditions. The law will apply if the relevant resource has more than 500,000 users from Russia daily. So a mobile app should have more than 500,000 users, or a website should have more than 500,000 users. As far as I understand, we should not summarize the users that visit different solutions. So this will be like 500,000 users for website and the same amount of users for SaaS solution or for other web resources. According to the law, the Russian authorities should adopt some guidance on how to count the users. As of today, there is no official guidance. However, there is a draft guidance, and most likely this draft will be finally adopted. According to the draft guidance, there should be 500,000 single visits by users from Russia daily. So there is a big difference here. As I mentioned, the law says that there should be 500,000 users. However, the draft guidance says that there should be 500,000 visits. It means that one user may visit your resource several times. The guidance says that the Cybersecurity and Data Protection Authority, with a difficult name Roskomnadzor, will ask the foreign company for the statistical information about the user visits. If this company does not want to give this information, then the authority will either use public sources to count the users. I believe that various web analytical services may be used for this purpose, or the authority will use some specific counting software to count these users. However, I don't know what is it actually, because this software has not been released yet. So if we have a website or app or anything else with 500,000 users, what will happen next? This web resource should meet some additional criteria. First of all, the Russian law will apply if this web resource is used for the processing of data of Russian users. Then the law will apply if there is the content in Russian language or the web resource use regional languages of Russia. Then the new law will apply if the foreign company accepts money from Russian natural persons or Russian companies. The payments can be done in any currency, not only rubles, but the main idea is that the law will apply if there are more than 500,000 users, plus they pay money to the foreign company. And there is one more criterion. The law will apply if the web resource distributes various marketing materials, advertisements intended specifically for Russians. So if you have the relevant amount of users, and if you have any of these criteria, not all of them, but any of them, then the Russian law will apply to your website or cloud-based solution or application. In addition to this test, there are several specific cases when the law will apply, and in these cases, the number of daily users does not matter. First of all, the law will apply if you have a kind of marketing network. So your system is used for distributing advertisements intended for Russian users. Advertising network. Then the law will apply to hosting providers if they host online resources used by Russian users. In fact, the hosting providers will never know whether they host such resources or not. So basically, the law may apply to any hosting providers all over the world. And thirdly, the law will apply to so-called organizers of data dissemination. These are foreign companies that own some IT system or website or app. And this system should support the exchange of messages between users. So basically, if you have some website, and if the users can register with this website and create an account, then if there is a function so that users can send messages to each other, or if they can post public posts on your website, then your website and your company will be called organizer of data dissemination. And in such a case, the law will apply to your company if you have users from Russia. And the number of users does not matter in this situation. At least this is what we have for now. I would like to mention that there is some additional legislation on the organizers of data dissemination. According to the Russian legislation, if your website falls under the definition of the organizer, then you must retain data about Russian users and about their correspondence. It means that you should retain their messages of any kind for 6 months, and you should retain their profile information and information about their activities for 1 year. And this information should be disclosed to the Russian security authorities upon their request. This legislation was adopted, as far as I remember, in 2014, maybe. But up to now, the Russian authorities apply this legislation only to large IT companies. Given that they mentioned the organizers in their new law, now they may try to focus on the enforcement of this legislation. There is a public register of organizers published by the Russian authorities, and the Russian Cybersecurity Authority keeps records of organizers of data dissemination. It is unclear whether the new law will apply only to those companies mentioned in the register or not. The reason is that the new law says that the government of Russia must adopt a decree explaining what organizers, what hosting providers, and what advertising networks should fall under the new law. So there will be some official document with criteria explaining how to identify the companies that will fall under this law. However, as of today, we don't have this decree, and I have not found any draft of this decree. So you should keep in mind that if you have any kind of organizer of data dissemination or hosting provider or advertising network, then you should monitor the Russian legislation and wait for the decree of the government. And now let's proceed with the requirements to foreign companies. Basically, there are 7 requirements that should be taken into account by global IT companies. The first requirement is that if the new law applies to your company and your web resource, then you should publish some web form for users so that these users can send you official correspondence and inquiries. There is a draft decree of the Cybersecurity Authority explaining that the web form should contain fields for the user's full name, contact details, and the message. These web forms should be placed on all websites falling and other web resources falling under the new law. The second requirement is the requirement to establish an office in Russia by 1st January 2022. This office must represent the parent company. There are several obligations and responsibilities that must be performed by the Russian office. My colleague Sergey will explain in detail what should be done and what kind of office should be established. The third requirement says that the foreign company must create an account at the official website of the Russian authorities. As soon as the account is created, the authorities can send official correspondence to this account, for example, various demands and inquiries. And this correspondence will be deemed as received on the day when the authorities upload this correspondence to the account. However, as of today, this official website does not work, and that's why it's impossible to create this account. As soon as the authorities launch the website, all companies falling under the new law will have to immediately create this account. The fourth requirement is that the foreign companies must apply to the register of the Cybersecurity Authority. The law says that, first of all, the foreign companies must create an account on the website of the authority. After that, the foreign companies should fill in the relevant information in their account and submit an application to the Cybersecurity Authority. The authority will record the foreign companies in a special register that will be published. The authority can also monitor the internet and record web resources and companies at their own initiative of the Cybersecurity Authority. So if you do business in Russia, then you should monitor this register, and if you find your company in this register, then you should consider compliance with the Russian law. However, once again, this register has not been published yet. We're still waiting for it. According to the new law, if there are less than 500 users for 3 months, then the company may apply for removing from the register. If there are less than 500,000 users for 6 months, then the authority will automatically delete the relevant resource from the register. Another important requirement is the personal data localization requirement. For the first time, this requirement was adopted in 2015. However, it was unclear whether non-Russian companies must fulfill this requirement in all cases. Now the new law says that if this law applies to your company, then by default, your company must comply with the localization requirement. For example, on the screen, you may see the case where there is a website owned by some non-Russian company. And according to the new law, this company has established an office in Russia. The hosting is somewhere outside Russia. And in order to fulfill the localization requirement, the non-Russian company must create a local database. Then the Russian office should notify the data protection authority of the location of this database. So basically, the authority should know the postal address of this database. After that, the data should go from the Russian data subject in the following order. First of all, the data goes to the website. For example, our data subject would like to fill in a web form. Then this data should be immediately saved by the local database within Russia. After that, it will be possible to create a copy of personal data and send it to the main hosting. Then the data will be processed on the main hosting outside of Russia, on the condition that there will be a copy of this data permanently stored in the local database. According to this structure, the localization requirement will be fulfilled. I would like to mention that there is some liability for breaching the localization requirement. In particular, there are fines for the first time breach and for the repeated breach. And the most notable cases are the cases of Facebook and Twitter. On the screen in the table, you can see the maximum amounts of fines. Facebook and Twitter were fined in lower amount for the first time, but still they failed to comply with the localization requirement, and the authorities initiated legal actions about them. The next requirement is the requirement to delete unlawful content. I mean the content unlawful from the perspective of Russian law. I can give you some examples of such content. What is prohibited? There are typical examples like online sales of alcohol, child pornography, gambling, information about suicide, or information about production or distribution of drugs. In addition, extremist or riot calls are also forbidden and prohibited. There are also very specific cases concerning information about World War II and concerning offensive information about the flag of Russia and other official symbols of Russia. So to sum up, there is a long list of prohibited information. And according to the new law, if the law applies to your website, then you should moderate this information. Otherwise, the authorities can apply some coercive mechanisms. And finally, the seventh requirement is the requirement to install a user counting software proposed by the authorities. But as I mentioned, this software has not been released yet, and that's why I cannot comment on it. Now let's talk about the coercive measures. You can see them on the screen. These measures can be applied by the cybersecurity authority without recourse to court. So they don't need any court decision for that. They can do it if they believe that a web resource or app or SaaS solution does not meet the Russian legislation. And the particular measures will depend on the particular violation. For example, if a company fails to open office in Russia by the end of this year, or if the company failed to create an account with the authorities, then the authorities will apply these measures highlighted with orange. They may prohibit advertising, they may restrict money transfers to the foreign company from the territory of Russia, and they can also inform users that a website breached Russian law. They are planning to do it by adding the relevant notices to the search engine results. So if a user would like to search for information with the Russian search engine, then the user may see a notice that this website possibly violates Russian law. After the first violation, the authorities will give a notice to the foreign company, and if the company fails to comply with Russian law within 30 days, then the cybersecurity authority will have the power to apply any of these measures, including blockage of the website and the prohibition to collect personal data. The prohibition will work in a way that the authority will prohibit a particular company from collecting Russian data. And also the authority will prohibit all other companies in Russia from sending data to this foreign company. It means that the cross-border data transfers from Russia will be prohibited for this company. If a company fails to block or delete unlawful content, then these measures will be applied. So basically any measures except for blocking the website. I believe that the reason is that the Russian law provides for other mechanisms how to block a website if it contains illegal information. Sometimes it will be necessary to receive a court decision for blocking, and in some situations this can be done without the court decision, but in different procedure. That's why the new law does not mention blocking in this case. And if the foreign company breached the personal data localization requirement, then all possible coercive measures may be applied without recourse to court. And here is some statistics showing that the authorities actively apply blockage for the infringing websites. The statistics is for 2019 because the report for the last year has not been released yet. We're expecting it by the end of July. Finally, what to do? First of all, I would say that if your company may fall under the described criteria, then you should audit the compliance of your web resource with Russian law and pay special attention to the localization requirement, to the content moderation rules, and to the advertising of your web resource. You should also add a feedback form to the web resource because it's not that difficult. Then you should choose your tactics. Either you will keep silence and wait until the authority will ask you to create an account and observe the law, or you will do it voluntarily. That depends on what kind of business you have in Russia. If you have a well-known company, and if you proactively market your company on the Russian market, then I would say that you should do it at your own without waiting for inquiries from the authorities. Then you should consider the establishment of the local office, but Sergey will explain it in more detail. And you should also keep monitoring all the developments concerning the new law, because this is a really new law, and we are still waiting for the additional guidance from the authorities and for the law enforcement cases. I truly hope that your company will never participate in the law enforcement procedures and you will never create these cases for our analysis. So now we have some time for asking questions. On your screen there should be a tab questions and you can specify them there. In addition, if we don't have enough time for answering all questions, then we can reply by email. So Sergey, do we have any questions?
Yes, I can step in and answer the ask you some questions we received before this presentation, if you will. So the first question: how does the new law cover activities, services on public blockchain infrastructures like Ethereum, for example, which are by definition geographically global? So the question directly relates to blockchain and your assessment of this.
Well, that's a difficult question, and it depends on whether your blockchain system will fall under the criteria. So I believe that you can easily have more than 500,000 users from Russia. The next question is, do you have a kind of app or web resource? If you have it, then you must comply. And to my understanding, the main focus of the authorities is to force you to create an office in Russia, because all other requirements can be easily fulfilled. So I would say that you should begin with the assessment of your system with the available criteria. But in case of blockchain, given that this is not that obvious, my personal tactics would be to wait for inquiries from the Russian authorities.
Yeah, and in my opinion, as I was listening to you, that the industry or sector in IT area is not that definitive. So you can be a blockchain, you can be a video game, you can be a social media, but the factors are absolutely different, like you explained.
Okay. Any more questions?
The next question is, please address obligations regarding blocking and removal of content. I think this was your some previous slide that was showing us the sanctions and the consequences. Can you show it again?
Well, yeah, of course, I can do it. Yeah, I believe this one.
Yeah.
So to make it simple, the Russian legislation specifies many types of content that is illegal. The general rule is that if there is some criminal or administrative liability for the distribution of certain content, then this content is unlawful. And it means that your website may be sanctioned one way or another.
Right.
The particular mechanism will depend on the type of the unlawful content. The general rule is that if some content is unlawful for whatever reason, then the cybersecurity authority may apply any of these orange mechanisms: inform users, restrict money transfers, prohibit to collect personal data, and so on. Any of them.
Can they do it all together?
I believe
or
that
the law
yes.
doesn't explicitly mention this?
From the wording of the law, I assume that it will be possible to do it all together. However, as you can see on this picture, it will be impossible to block access to a web resource containing this illegal information, because the Russian legislation provides for several different procedures, and these procedures will apply depending on what kind of content you have. For example, if you have some kind of criminal content, for example, if you would like to sell fake documents, then in such a case, the authority will go to court and receive a court decision to block your website. But in other cases, for example, if this is a case about riots or illegal activities affecting the security of the Russian state, then it will be possible to block access without the court decision. So in general, this is how it works. Thank you.
Thank you, Stanislav. And I think I have the final question for you before we change speakers. Can you shed some light on surveillance laws in Russia and how Russian intelligence agencies may have access to personal data that is processed in Russia?
Well, this is a big separate topic. The main idea is that if your company falls under the definition of the organizer of data dissemination, then the law says that you must retain information about users and their messages, and this information must be stored within Russia. This is not the personal data localization requirement. This is a completely different requirement. So if you are the organizer of data dissemination, then you retain the messages and information about users, and then you must provide access to the authorities to these messages. So basically, you must create a kind of backdoor to your data storage so that the authorities can access the data and see what's there. If you don't have
the Yarovaya law?
Yes, that's correct.
Okay, so and that was the Telegram case where they failed to provide an access to Federal Security Service, correct?
Yes. So basically, there are several options how to create this backdoor. Option one is that the authorities can inquire and you can respond and give the necessary information. The next option is that if you have encrypted communication channels, then the authorities may ask you for the encryption keys, and this was the case of Telegram.
Right.
Or the third scenario is that the authorities may ask you to install specific software on your Russian data storage, and then they will take the information automatically. But once again, these rules apply only if this is the organizer of data dissemination. If you don't fall under this definition, but still you process personal data of Russian nationals, then you must comply with the localization requirement. And the localization requirement basically says that you must process the data with the use of databases located within Russia. But no one will access these databases, so the authorities will not ask you to show the databases. This is only for you, and the authorities only need to know the address of these databases to check that you really have them. Sergey, one minute. I see that we have a question. You mentioned Roskomnadzor, Russian Data Protection Authority, and the Cybersecurity Authority. Are those different authorities? Well, this is one and the same authority. I don't want to use the term Roskomnadzor because it may be difficult for the audience to read this. And that's why I use the both terms, Data Protection Authority and Cybersecurity Authorities. But exactly, this is one and the same state body. And basically, this is a big body with regional divisions across the country. So they have thousands of people there. So Sergey, now I think that we should switch to your slides.
Yes, we have 20 minutes, and I think we should change. We're again sorry that we cannot respond to all questions. I see that one more appeared, but we have all email.
In any case, we will respond by email. So for sure, you will get your answer.
Okay, Stanislav, please change the speaker, and I will pick up.
Okay. Here you go, Sergey.
Yeah. Can you see the slides?
Yes, please continue.
Okay. So my part is on, hello again, everyone, and thanks for joining us today for this new IT law. And my part of the presentation is with regard to corporate issues and how to open an office in Russia. Since Stanislav explained the importance of that part and the term, which is January 1, 2022. And again, not too much time left for these corporate issues. So we must concentrate and open an office in Russia by the date in order not to be blocked, as Stanislav has mentioned. We have three options to establish corporate presence in Russia. All of them are listed on the slide. First two are very similar, and I will try to explain why they're similar and in what parts. And point number three, which is called subsidiary, or in other words, a local legal or business entity, is a bit different because it's a separate company located in the territory of Russia. Here you can see the differences between branches and rep offices which we have in Russia. First of all, it need be mentioned that neither a branch office nor a rep office are legal entities. So they are considered basically rep offices that represent, for example, the interests of the company, and they don't have separate corporate documents, for example, like in rep office. In branch office, they, in comparison with the rep office, they do all functions of a parent company, and basically they represent them because of that. So if you need to approach a parent company, for example, you can do this through a branch. Again, establishment of a branch or rep office will create a physical presence of a foreign company, and these entities, these offices, are regarded as standalone units of that company. But again, this is not the separate legal entity. Speaking about a subsidiary or a local entity, we have quite a few of different establishments. The first one is LLC, or limited liability company. The second one is a joint stock company, which can be divided into two groups, private and public joint stock companies. And we also have other commercial and non-commercial entities like units or associations, for example, that can be opened in Russia. But the most easy to establish and to maintain will be in number one. It's a limited liability company. Usually foreign companies use that particular form of establishment because of the process to register this company, the timing, and the money that you need to spend. And of course, for joint stock companies, from the very definition, it makes sense that for many of them, you don't have to be listed on the stock exchange. So there is no need in opening a joint stock company. For registration procedure, you need to spend about $50 for establishment of a local entity, and the process will take about 1.5 months. For branches and or rep offices, there is a mandatory accreditation procedure, which is different from the registration of a subsidiary. It takes a bit more time, and the process is more strict, and you need to spend, of course, more money, as you see, for this for opening of that office. On this slide, you can see the main documents that you need to present for registration or accreditation purposes. Basically, they are similar, and at the same they are different. In both situations, you need to file an application. You need a charter. For subsidiary, you need a separate charter. For branches and reps, you need to have presented the charter of the parent company. You need a decision to establish a subsidiary or a rep office. You need a trade registry extract, as well as in the subsidiary. But again, the processes are a bit different. You will also need translation. Many clients would ask, what about translation? Yes, we have state language, which is Russian. All authorities read and reply in Russian, so you need translation, and certain authorization and legalization factors need to be also complied. In terms of corporate management, you can see here that there are also some differences. For example, for subsidiary, they usually use two-level management structure: the general meeting and the executive body, which is CEO. The CEO can be a physical person, which is usually the case, and also the company can choose another company, another legal entity to act as the executive body. For branches, they will usually have the internal policy of a parent company and the head who will be leading the branch or rep office, usually the director of the branch or the director of the rep office. One more thing to remember, that if you want to appoint a foreign citizen, he will need to obtain a separate work permit in Russia and certain migrational documents. That is why you need to consider certain additional costs and additional timing, and that's why sometimes you need to choose between the local person or a foreign person, but in that case, foreign migration laws and work permissions need to be complied with. Tax issues. Yes, in both situations, with a branch or rep office or subsidiary, they act as taxpayer in Russia, but in the situation of subsidiary, they can use certain privileges and simplified procedures to have the economy on paying taxes. In some situations, it can go down to even 6% instead of, for example, 20%. For branch office or rep office, you can't use the simplified taxation systems. You will need to pay in accordance with the law, and you cannot cut it down. So I'm not a tax lawyer, but again, in terms of taxation, foreign clients would prefer to use local subsidiary to save on taxes. Here is one more advantage of the subsidiary, of the branch or rep office, that dividends, they are not subject to taxation. And when the money are coming to the parent company, you don't have to pay taxes on that particular funds. So from that perspective, yes, branch and rep office may have certain advantages. A couple more things about liability, that since branch office and rep office are basically under control of the parent company, yes, this parent company, they will be held liable under Russian office obligations, and that is the idea behind this this law, to have some company presented or opened in Russia, to bring it to liability because of the parent company unlawful, for example, actions. For subsidiary, usually the answer will be no. Subsidiary is a separate company, as I explained from the beginning. That's why they respond according to their obligations separately from the foreign company, for example. That's why they will be sued separately. But in cases where, for example, the parent company instruct its subsidiary to transact, to enter into certain transactions, to execute agreements and deals, in certain situations, the law says that the parent company can bear joint liability, and we have to keep it in mind as well. So again, what are the main obligations under the law? And we have to look for Article 7 of that law, that the local office, when we opened, need to do. First of all, they must accept and process correspondence from Russian nationals. They must, for this particular measure, we advise to open a postal service and to have the postal address, because sometimes the legal address and the postal address are messed up, and this is not we would like to recommend in particular with compliance with this law, because you will receive formal letters and official letters from Roskomnadzor, as Stanislav explained, and you need to respond. Also, the second point is that the local office will need to comply with judgments and local decisions of the authorities. That's why we need to open this office. We need to represent the company in the court. So again, all litigations will be directed against the Russian local company. And of course, as Stanislav already explained, they must block or delete the content which will be recognized or is recognized as illegal under Russian law. So they will be responsible for that. This is a to-do list after office establishment, because you will ask the question, okay, we decided to open, we decided, for example, to open a subsidiary, so what we need to do? Of course, first of all, the decision lies always with the client. There are different things to remember and to compare what we are discussing today, and the choice will depend on various factors. So the second, what we need to understand, that there are different situations. For example, a situation when we are acting as the company and we do some business, that is one thing, or we're just opening an office to create compliance or to demonstrate compliance, and we don't do we're not planning to do any kind of business, and that's why, for example, we're gonna file zero tax declarations. That is another thing. But again, if we decide it, then the office, in addition, must have a bank account. You also need to be registered with some additional authorities, which is the statistical authorities, the Russian pension fund, and the Russian social fund. This is created to protect the statistics of the company and to protect the interests of the employees, because they need to have the pension, they need to have social packages, etc. So this will protect them from the government and administrative standpoint. Stanislav mentioned that for data protection purposes, they also need to file a notice and be registered with the Register of Data Operators through Roskomnadzor website. And there are some other stuff, for example, notifying of Ministry of International Affairs for the conclusion of employment contract with a foreigner. Before I talked about appointment of a foreigner as a director of the company, for example. So all this need to be done, and these are additional timing and costs which we need to understand. I think we have 2 more minutes for questions. Again, if we are not able to respond to all of them, these are our contact information, and we'll be always happy to answer additional questions in writing and via emails, if you will. Stanislav, are there any questions?
Sergey, yes, we have some questions. Thank you so much for your slides. Please return the last slide with the contact information. Yes, so first of all, we have several questions about the recording of this video and about our slides. The recording will be available for sure, and I believe that we will also share our slides with the attendees, no problem at all. And specifically to you, Sergey, we have a question. Could you please tell if it is necessary to establish a new representative office or subsidiary if we already have one in Russia? If no, do we need to give our subsidiary more power? Because now it is responsible only for small questions. Sergey,
yes,
please.
it depends again on the form of establishment that you have. So if it's, for example, some rep office that is already established and the functions of the same are determined by the policy of the parental company, perhaps you need to extend and amend this policy to give them, as you mentioned, more powers. If it's a separate subsidiary, I think you can use this as to demonstrate the compliance with this law, again by registering, by creating an account with Roskomnadzor through this company, and by providing the Roskomnadzor with this additional information on this local business.
Okay, thank you. And finally, we have several similar questions about cloud solutions. Whether I believe that these questions are to both of us, whether the new law should apply to cloud-based solutions in various cases.
Well, again, I can quickly start, and Stanislav, if you don't mind, you can go deeper. In our point of view, the sector and the industry that is behind the IT company, it doesn't matter. But what matters is 500 plus thousand of audience that or the clients or
any users, basically.
Any users, yes, that basically this IT system has. And what Stanislav mentioned is that you need to be registered with Roskomnadzor.
Yeah, so basically I would support this. As we understand the new law, the particular industry will not matter at all. So if you have some global cloud solution that works everywhere in the world, just count how many users from Russia you have. Because if you have the relevant amount of users, plus you meet at least any of the additional criteria. For example, you accept payments from the Russian users, then for sure the new law will apply. And there is a question about cloud hosting. This is a more complicated thing because the cloud hosting may fall under two different rules. It may fall under the new law if it meets the criteria on the one hand, and on the other hand, the law says that it should apply to all hostings if they host services intended for Russians or used by Russian nationals. Regarding the hostings, we are still waiting for the decree of the Russian government that should establish additional tests for identifying the hostings that will be subject to the new law. So once again, thank you all for joining us. We hope that it was useful. Please, if you have any feedback or comments or questions or concerns, or maybe even objections, please don't hesitate to contact us, send us a message, and have a nice day. Bye-bye.
Have a great day. Bye-bye.